Hello, hello everyone. Thanks for joining us. Today, myself, Estefania Aleman, and Marcelo Pupe we are collaborating in this webinar. I work for ICASA. I manage the trust licenses for ICASA in Panama and BVI, and I oversee all matters related to family business, estate planning, succession, transition of family businesses to the next generations, and I see I help clients with their estate planning vehicles in general. We have also used structures, trust structures for other purposes, which related to estate planning, asset protection, but also related to commercial purposes, such as guaranteeing commercial obligations. So today, my part of the webinar will be about, I'll explain trust in general, what they mean, their benefits. I'll explain how the formalities of transferring assets in favor of trust, and then I'll go on to explain a little bit the difference between the different types of trust. After I am finished, Marcelo, and he'll address matters regarding how or affect Brazilians who act as settlors of a foreign trust, or Brazilians who act as beneficiaries of a foreign trust. So I'll start sharing my and then at the end of the webinar, we will leave time for questions. So feel free, you can put your questions in the chat, and we'll answer them at the end, and we will also open a space for free questions. So I'll start with my presentation. Okay, as I mentioned, I work for ICASA González-Ruiz and Aleman, which is an economic group that acts as a corporate service provider in different offshore jurisdictions. I'll start with by explaining what is a trust. I'll explain the definition of a trust under Panamanian law. Panama has a civil law system, and afterwards the definition of a trust under common law, which is the definition used for trust by the US, England, and all jurisdictions in the Caribbean. So Panama and common law, the purpose of a trust is the same. They have some different legal characteristics that we'll see throughout this presentation. So under Panamanian law, a trust is defined as a juridical act through which the settlor transfers assets in favor of the trustee, who obliges to administer and dispose of these assets in favor of beneficiaries. And the beneficiaries, the settlor may be a beneficiary as well. Or the settlor may administer the assets in favor of fulfilling a determined purpose. Under common law, a trust is a legally binding agreement through which a person known as the settlor transfers assets to another person known as the trustee, who obtains legal title of the trust assets, not for its own benefit, but for the benefit of other persons known as the beneficiaries, which may include the settlor, or for a determined purpose. So under both law system, the settlor transfers the assets to an autonomous patrimony, and that autonomous patrimony, it's administered by a trustee in favor of the beneficiaries. Let me switch to the next image, to the next, give me 1 second. Okay, perfect. So some of the benefits of a trust structure are tax planning and efficiency. It works as an estate planning structure. A trust structure avoids disturbance upon the death of the patriarch. It provides confidentiality. It has great benefits for asset protection, wealth preservation, and avoidance of forced heirship. Under Panamanian law, there is a 3-year statute of limitation from the time when the settlor transfers the assets to the trust. What this means that if there is a creditor of the settlor or a third party that wishes to challenge the transfer of the asset into the trust, that party has a 3-year period to initiate that claim, and that claim would be through a judicial proceeding. A trust also helps in the transition of family businesses to future generations. You can manage a family business or shares of a family company through a trust structure. You may use a trust to guarantee a commercial obligation or to fulfill a determined purpose established by the settlor. So here, it's only some examples of how a trust structure may look. It's very important to take into consideration that a trust is a dress made to the measure of the needs of the settlor. So the trust structure is very flexible, and it may, contain the necessary characteristics to adequate to each specific case. On the left, we see a trust that owns shares of an underlying company, and under that underlying company, there are other subsidiaries, real estate, and securities. We have shares of multiple underlying entities, or it may also have as in the trust, and that's what the image on the right shows. It basically shows real estate and bank accounts and shares of an underlying company directly in the name of the trustee on account of the trust. And really, as I mentioned, it depends on the particular situation. How do you structure the trust? Here, in this next slide, I am going to explain the transfer of assets to a trust. So what are the formalities that need to be met to transfer assets to a trust? So when we are talking about shares that we want to transfer in favor of a trustee on account of the trust, the shareholder endorses or transfers those shares in favor of the trustee on account of the trust in accordance to the formalities of the jurisdiction in which the company that issued the shares is incorporated. And then basically the share register of that company is updated to reflect the change in share ownership. When we are talking about real estate, the real estate usually is registered in the registrar of the jurisdiction in which the real estate is located. So basically, when it is transferred in favor of the trustee on account of the trustee would need to be registered in that registrar as the owner of the real estate. When we have bank accounts or investment accounts, basically the bank account or the investment account is opened in the name of the trustee on account of the trust, or it may also be opened in the name of an underlying company, and the shares of that underlying company are then issued in favor of the trustee on account of the trust. A trust may also have movable assets like artwork or machinery or really any type of movable assets. So how are those movable assets transferred to the trust? Basically, they are describing the trust deed. If possible, we place a small plate on the movable asset indicating that it is a trust property of such and such trust. And we also make custody. If we are talking about an artwork or a boat or a, something that the settlor or a beneficiary is going to be using, we do a custody agreement with that person to establish that that person has the right to enjoy the asset during his or her lifetime, but that really the owner, the legal owner of that asset, is the trustee on account of the trust. You may also do pledges in favor of a trust or mortgages in favor of a trust. In this case, in these cases, the pledge or mortgage are included in the trust deed as part of the trust assets. And in parallel, the trustee celebrates a pledge or a mortgage agreement with the corresponding counterpart. And in this slide, I do a comparison between Panama Trust, which is a trust governed by civil law, and BVI Trust, which are trusts governed by common law. So for Panama Trusts are governed by Law 1 of 1984 and its amendments, and BVI Trusts are governed by the Trustee Act and the Vista Act, because in BVI we have ordinary trusts that are governed by the Trustee Act, and we have what we call Vista trusts that are governed by the Virgin Islands Special Trust Act. And basically, the parties to a trust under Panama law or under BVI law are the same. In Panama, there is no perpetuity period, and in BVI, the perpetuity period is 360 years. In Panama, trust assets do not pay taxes, and the same applies in BVI. In BVI, trust must only pay a stamp duty of $200 upon their constitution. In both jurisdictions, the trust agreements are private, but in Panama, if the trust owns real estate in Panama, then the trust agreement needs to be registered in the Panamanian registrar. And that may be the case in other jurisdictions where the trust owns real estate in the direct name of the trustee. If the real estate is owned by an underlying company, which shares are in the name of the trustee, then there is no need to register the trust agreement. And well, in both jurisdictions, the settlor and the protector may reserve powers, which means that they may have certain powers to give instructions to the trustee regarding appointment of beneficiaries or the exercise of dispositive provisions. And to follow up on that subject, as I explained in the beginning, a trust is a dress made to measure. So there are different types of trust. And here I try to summarize or categorize types hybrid, a hybrid between these categories. So one type of trust is a revocable trust, and what this means is that the settlor may revoke the trust and the assets sell into the trust and reverse those assets to him or her. In an irrevocable trust, the settlor cannot revoke the trust, and the trust assets may only be distributed to the trust beneficiaries. The settlor may be a trust beneficiary, but he may get those assets through a distribution and not through a revocation. That is basically that the trust is giving him back the assets that settlor initially settled into the trust. We also have the fixed trust, which is where the dispositive provisions of the trust in regards to the beneficiaries are fixedly established. This means that in the trust agreement, you establish the percentages of benefit of each of the beneficiaries regarding the trust assets. But a trust may be a hybrid between a fixed trust and a discretionary trust, because the beneficiaries may be fixed, but that doesn't mean that the trustee may not have certain discretionary powers. And a discretionary trust, well, we have trusts that may be 100% discretionary, and as I mentioned, we may have trusts that are partially discretionary. So what does discretionary means? It means that the trustee has discretion regarding the administrative and dispositive provisions of the trust. It has discretion regarding the distribution of capital and income between the beneficiaries. And due to the extent of the administrative and dispositive discretions, the settlor may provide the trustee a non-binding letter of wishes, setting out his or her wishes on matters such as distributions and investment of the trust fund. So what does this mean? It means that the settlor may send to the trustee a letter of wishes establishing what are his or her wishes regarding the administration of the trust. Even though the letter of wishes is a non-binding document, the trustee will use the letter of wishes as a guidance on the administration of the trust, always that the wishes are, are within the allowed legal framework. And we also, another type of trust is the purpose trust. And the definition of a purpose trust is a trust created for a specific purpose that must be clear, so that anytime it is possible to state whether a proposed use of the assets subject to the purpose trust is within the scope of the object. And just to put an example, a practical example, for example, in BVI, we have used purpose trust to guarantee commercial obligations or to protect certain types of assets, which are not necessarily intended for estate planning. In Panama, we use purpose trust very often to guarantee commercial obligations. So this is the end of my presentation, and Marcelo will follow up with his presentation, and in the end we will have time for questions.
Okay, thank you very much, Stefania. I want to start thanking everybody for coming for this webinar. I think the trusts are now a trending topic in Brazil, at least since last Sunday, when our federal government enacted a brand new provisional measure, a medida provisória, regarding the taxation of income earned by Brazilian residents from controlled foreign companies and trusts abroad, likewise. And the reason why this is a trending topic nowadays, especially nowadays, is because as a result of the devaluation of the Brazilian real in comparison to the US dollar, according to Bloomberg, $137 billion fled Latin America to offshores last year. In comparison to 2021, we had an increase of 41%, of Stefania said, state planning, but also for asset protections. We've been seeing this is a real trend from Brazilian wealth families that every time they are trying to send money abroad to protect their state and their patrimony from some oscillations. So here at our office, PMZ Advogados, we have dealing with international matters, particularly with ICASA. We've been working closely, and our expectation is that the number of offshores and the number of trusts that are going to be constituted abroad by Brazilian citizens are going to increase from now on. That being said, I'm going to start my presentation, and this is all new material, I would say. And I remember, Stefania, when we were discussing the date and time of the webinar, we couldn't have thought that the government would enact medida provisória so close to the webinar. So I would say that this is a very good opportunity for us all to speak about a very fresh, a brand new theme like this. So let me share my screen with you and start the presentation. Okay, I'm going to start by talking about the general framework according to Brazilian law. And this is the reason why we are all here today. Up until at least at the end of April, Brazil had no law in force regarding trust. And I would say, actually, we are still like trying to figure out how things are going to be from now on. But I would say Brazil has no law in force regarding trusts, because the new MP, the Medida Provisória 1171, provides for the taxation of income earned by individuals residing in Brazil in financial investments, controlled entities, and foreign trusts. We don't have yet a federal law regarding the trust as it is. We just had like a new MP from the government to offset the taxation of the individual income bracket that was recently modified by the government. So we don't have a legislation on trust. Brazil is not a contracting party to the Hague Convention on the applicable law to trust and on their recognition. And we would say that generally the trusts are effective in Brazil, except if they offend national sovereignty, public policy, and morality. And the situation of the created by the legal gap is that, unlike what happens in Panama, BVI, and other common law jurisdictions, the absence of legislation on trusts results in courts and tax authorities making their own interpretations on a case-by-case basis. And this is now a changing scenario. And why I say this is a changing scenario? This is a changing scenario now because with the MP, and we have two bills in the Congress, one from 2020 and another one from 2022, that are trying to somehow regulate the matter of trusts, the fiduciary agreement, and also the trust. And because of the MP for Medida Provisória from April the 30, we are now going to face a scenario where this matter is going to be object to several discussions, and banks, institutions, law firms, they're gonna speak out and contribute, because the MP, as we say, the Medida Provisória, as we know, actually, it needs to be transferred or transformed to or converted into law. And for that to happen, some debates are gonna take place in the Congress, and it's very likely that we're going to have some changes to the text that was published in the Diário Oficial the past Sunday. Okay, that being said, we have to discuss a little bit about the obligations for a person in Brazil due to constituting in a capacity of a settlor a foreign trust. We had a scenario that is now, I would say, outdated, and with the new MP 1171, we have some obligations that I want to disclose, of course, that this is a webinar that we are holding on May the 3rd, 2023, and everything can change, okay? So the presentation is being made according to the text published Sunday, April 30. Every other modifications, eventually, we're gonna have to discuss again, and maybe I'll call another webinar so we can discuss further details over the text of the MP. But according to what we have now on hands and on the table, the MP tries to distinguish the moment of the transfer of the assets. And I would make my first of criticizing the text of the MP, because by definition, in the trust, the settlor transfers ownership of some assets to a trustee on account of the trust, so that the trustee would manage such assets in favor of the beneficiaries. And now we have a new situation as per the text of the MP 1171 2023. And that is because, according to the MP, the assets and the rights subject to the foreign trust will be considered as remaining under the ownership of the settlor after the institution of a trust. And that's my point here. As I said, for definition, the assets, when constituting a trust, they are transferred to the trustee on the account of the trust. But the MP says that even when a settlor, a Brazilian settlor, constitutes a trust, the assets of the trust or transferred to the trust or to the trustee will be deemed as remaining under the ownership of the settlor after the institution of a trust. And that brings an obligation to the settlor to keep record of the assets in his own tax statement, declaração de imposto de renda. And this seems to me, I could say a Frankenstein, but that is a jabuticaba, a Brazilian fruit that does not comply with what we have seen in other common law jurisdictions. And in the same situation, also the MP says that the assets and rights subject to the foreign trust will be considered as becoming beneficiaries' property at the time of the distribution or transfer by the trust to the beneficiary or the settlor's death, whichever occurs first. So we would have a specific situation here where, even though the trust had been constituted, the ownership of the assets would remain under the settlor upon the constitution of the trust, and would not become property of the trustee. It would be transferred from the settlor to the beneficiary at the moment that the trust did say so. So this is something that will for sure demand some further discussions. And I would say that it would be reasonable to think that this deserves some changes during the debates in the Congress, okay? Starting on January 1st, 2024, Brazilian residents in the condition of settlor of a trust, as I said before, will be required to keep the ownership of the assets as his own when filling out his individual income tax statement. This goes against, I would say, one of the main purposes. Let me just mute someone. Okay, I'm sorry about that. So this goes against one of the main characteristics of a trust, that would be the actual transfer of the assets to the trustee on account of the trust. And as many of our clients, they constitute trusts to have the formal segregation of their own patrimony compared to the trust patrimony, just to make sure that this patrimony would not be affected by his enterprises and his own businesses. When the MP comes and say that Brazilian residents need to keep record of the ownership of such assets in their own tax statement, we don't know the outcome of this. We don't know how the judges are going to behave before these situations, and if they will understand that the assets were transferred to a trust, or if the assets remain under the ownership of the settlor. So this is another point that we're gonna keep record of, just to make sure that when the Congress start the debates about the MP, these eventually will need to be modified. And on the other hand, in the same situation, beneficiaries residing in Brazil are going to need to act likewise when receiving assets from the settlor or the trustee on account of the trust, regardless if this occurs during the settlor's life or upon the settlor's death. So the main obligation from now on would be the obligation to keep record of the ownership of the assets on settlors on declaração de imposto de renda, individual income tax statement. Furthermore, there is a normative ruling issued by Brazilian Federal Revenue number 2219 from 2022 that says that foreign trusts holding assets located in Brazil, whether they are real estate, they're vehicles, market investments, equity interests, they are required to register before the CNPJ, the National Registry of, form the list of its final beneficiaries. So let's say that a lot of our clients, Stefania, I believe that it happens to you too, comes to us and say, oh, I wanna shield my patrimony. I don't want anybody knowing that I hold some assets. I wanna therefore constitute a trust for this reason. But Brazil's federal revenue says now, starting from December 2022, that those legal entities, if they hold assets in Brazil, regardless of the nature of those assets, they are obliged by law, they are required by law to inform their final beneficiaries. And therefore, even if the settlor constitutes a trust and transfer the assets to the trust, if such assets are located in Brazil, these trusts or these controlled foreign companies are going to be required to inform the federal revenue the list of the beneficiaries. You want to say something, Stefania?
Yes, in regards to beneficiaries, so now it's, a lot of jurisdictions have private registers of beneficiaries, and Panama and BVI have private registers of beneficiaries. In both jurisdictions, if you have a trust and that trust, well, in BVI, if you have a trust, you can register the trustee as the beneficial owner. In Panama, if you have a trust and the trust is discretionary, you can register the trustee as the beneficial owner, only if the trust is discretionary. But that doesn't mean that the trustee doesn't need to have the due diligence of the beneficiaries and you know, of the source of funds of the settlor, etc. Because I have gotten the question like, oh, so because I establish a trust, does it mean that I do not need to disclose who the beneficiaries are? Like, nowadays we live in a world that has changed, that it is not the same world that it was 10 years ago regarding know your client measures. So to establish an underlying company, or to establish a trust structure, the settlor and the beneficiaries need to go through a due diligence process.
Okay. There's one thing that is also interesting, because until the enact the edition of the MP 1171, since by definition the settlor, when constituting a trust, transfer the ownership of the assets to the trustee on account of the trust, we would recommend our clients to record such transfer in their own tax statement, individual tax statement, declaration, the declaração de imposto de renda da pessoa física, with the write-off of the assets. And then they would also bank quarterly or annually, depending on the case. But the question mark that remains nowadays, and I would say that this presentation has more questions than answers, is what is going to be from now on, because some clients, some Brazilian citizens, they recorded the transfer of their assets to trustees on behalf of, on account of the trust, I mean, and now the MP says that the settlor must remain as the in his own ownership over the assets, even when constituting a trust to a trustee. So this is a point that needs to be clarified. As I said before, the MP is from last Sunday, so we are on Wednesday now. We have very few comments from lawyers and bankers. The federal revenue itself did not say anything about it, but in the next month, I believe we will have some or more news in regard to that, because not only in terms of definition, but in practical terms, that's the main concern of our clients. They don't want to talk about doctrine. They don't want to talk about what would be the right thing to do. They want to know what the federal revenue considers and think it's correct to be done, because they don't want to get any fees and any penalties from the tax authorities just because they're filling their tax statements in a wrong manner. So we're going to have to wait a little bit to see the outcome of this. Okay, we talk a little bit about the obligations for settlors, and we also need to talk a little bit about the obligations for beneficiaries of a foreign trust. Until MP, as I said, 1171, there was no express guidance from the federal revenue on filing out the individual income tax statement, declaração de imposto de renda de pessoa física, to report income or assets held abroad through foreign trust. There a product anymore in Brazil, I would say, and the applicable tax treatment, income or capital distributions, and the way in which such distributions shall be reported and declared will need to be analyzed on a case-by-case basis. And as a law firm working with foreign trusts, we're gonna take a deeper look into each of clients' individual needs and situations, just to guide them correctly according to the new reality brought by the MP 1171. In fact, MP 1171 is a game changing, because starting on January, and just a observation, this MP needs to be converted or transformed into law. So as I said before, we are considering during this webinar the text of the MP as published, but eventually we're going to have some changes to it during the discussions and debate in National Congress, okay? But according to the text published on last Sunday, starting on January 1st next year, 2024, income earned by individuals residing in Brazil in financial investments, control entities, and foreign trusts will be taxed with the individual income tax, o imposto de renda das pessoas físicas. And according, likewise, with the Article 2nd of the same MP 1171, individuals residing in Brazil will compute separately from other income and capital gains in the annual statement, the income from capital invested abroad in the form of financial investments, profits, and dividends from control entities and assets and rights subjects to trust. We have a new situation now in terms of tax rate, the tax bracket, since up until the addition of MP 1171, the federal revenue had pronounced in one situation, 2020, solução de consulta. I'm going to speak just a little bit in Portuguese because of the Portuguese Brazilian audience. The solução de consulta COSIT number 41 from 2020 determined that the income earned by individuals in Brazil from foreign trusts should be taxed with the income tax, but at a higher rate, 27.5%. And now, with the new MP 1171, the income will be subject to the incidence of individual income tax, imposto de renda das pessoas físicas, at a progressive rate, with no deduction applied from the calculation base. 0 to 22.5. As we all can see, and we are smart, at least we are not dumb, we are talking about 0% if the income does not exceed 6,000 reais, which would be like $1,000, 15% on the annual portion of income that exceeds 6,000 reais and does not exceed 50,000 reais, which be something around, I would say, $1,000 to $10,000, and 22.5% on the annual portion of income that exceeds $50,000. By means that, in terms of practical situations, we are talking about the 22.5 tax rate, individual income tax rate, because people that constitute foreign trust and control entities abroad, they send big money, they don't send small money. And when they get the money back and when this money gets available to them, it's very unlikely that's going to be under 50,000 reais. So even though the MP talks about the progressive tax rate, I would say that this 22.5% rate would apply in the most of the cases. Furthermore, the MP also deals with another situation that was unclear up until the enactment of the MP 1171, because there has always been a discussion on when the individual tax income imposto de renda would apply and when the ITCMD would apply. And as per the MP 1171, starting January 1st next year, the transfer of the assets by the trustee to the beneficiary on account of the trust will be deemed the legal nature of transmission free of charge by the settlor to the beneficiary, consisting of a donation if it occurs during the settlor's lifetime, or consisting of transfer causa mortis if due to the death of the settlor. Therefore, this ITCMD, which is the donation and or inheritance tax, will apply. The ITCMD is a state tax at a rate of up to 8%. So this gap was also now fulfilled somehow, because the MP separates situations where the income will be earned individual income tax, imposto de renda da pessoa física, and when transfer applies, whether as a result, whether during settlor's lifetime or as a result of settlor's death, the ITCMD will also be applied. That being said, let's move forward just to bring to the table some implications in regard to controlled foreign companies under Brazilian law. As most of us know, foreign companies must register before the CNPJ, and also, as I said before, inform the federal revenue the list of their final beneficiaries. And we're going to talk a little bit about situations in two ways. When entities in Brazil eventually are sending money abroad, dividends, let's say, to offshores, and also when those controlled foreign companies are sending to Brazil money, let's say also dividends, and we have different situations. As for the first situation, we have in Brazil in force a normative ruling number 1037 from 2010 that lists countries with favored taxation and privileged tax regimes, which we call tax havens, paraísos fiscais, and income paid by Brazilian source to persons or entities located in tax havens is subject to a withholding individual income tax, imposto de renda retido na fonte, rate increase at 25%. Unfortunately, BVI and Panama, they are both considered tax havens under such normative ruling 1037 from 2010. And the criteria adopted by the federal revenue when doing so was considering countries, one, which does not tax income, two, which tax the income at a rate lower than 20%, or three, whose legislation does not allow access to information related to the corporate composition of legal entities or their ownership. So when Brazilian sources are paying money, are sending money abroad, are paying dividends, let's say abroad, if such entity is located in a tax haven, we're going to have the incidence of a withholding individual income tax, a rate increased at 25%. On the other hand, MP 1171 from 2023 also provides for the taxation of income earned by individuals residing in Brazil, paid by controlled foreign companies at a progressive rate of 0%, 15%, and 22 and 5.5%. And we have some specific situations here. There's a division in regards to profits generated from 2024 on and profits generated until December 31st, 2023. As for the first situation, profits generated from January 1st, 2024 will be taxed annually at the end of each year, regardless of the availability to the tax holder or to the beneficiary. So basically, if the MP passes and becomes law as it was proposed by the federal government, starting January 1st, 2024, profits generated by controlled foreign companies are going to be taxed at the end of each year. Profits generated until December 31st, of 2023 will be taxed at the moment does not become available to the beneficiary. It's not gonna be taxed as it's going to happen with the situation from January 1st on. Losses generated from January 1st, 2024 can be compensated, and the individual may deduct the income tax paid abroad by the controlled foreign companies. We have, as I said before, and we are almost done, two bills in the National Congress, one from 2020 and one from 2022. The first proposed the formal introduction of the fiduciary agreement to Brazilian legal system. And despite the similarities, it is not the trust. The main goal is to establish the legal segregation between the state of the settlor and the state of the trustee. And however, this bill 4758 from 2020 does not provide for the tax treatment of the fiduciary agreement. This bill was approved by the House of the Representatives, the Câmara dos Deputados, in August last year, and was sent to the Federal Senate, Senado Federal, in October last year likewise. On the other hand, bill number 145, which is a Projeto de Lei Complementar, 145/2022, provides for the applicable law to the trust, formally recognize its effects in Brazil, and establishes general rules regarding the tax treatment to be given to transfer of properties, capital gains, and income related to the trust. This bill, I believe at least, is going to suffer a lot with the addition of the recent and fresh brand new MP 1171, because it talks about not only the ITCMD, which is the donation and inheritance tax, but also talks about the taxation with the individual income tax. But now I would say this is outdated. MP 1171 2023 will surely be taken into consideration by the Congress when an 2022. It's kind of sad to have such overlap of matters from different authorities trying to discuss the matter ever since 2020 at least, and now the federal government to collect more money, issue and enacted the new MP, and we have overlap of matters in both these legal acts. The conclusion, considering the major innovations brought by the MP 1171, would be that, one, the assets and rights to be declared in settlers are going to be declared in settlers' individual income tax statement. So we don't have or wouldn't have that formal segregation of the estate of the trust or the trustee and the estate of the settlor. Two, transfer to beneficiaries are going to be treated as donation if it occurs during settlor's life, or causa mortis if because of settlor's passing. Hence, they're going to be taxed with the ITCMD, a state tax with a rate of up to 8%. Financial investments are going to be taxed with individual income tax at that progressive rate of up to 22.5%. And the taxation, it's going to happen at the moment of the availability, whether redemption, amortization, disposal, matural, or liquidation. And finally, as we said before, in regard to controlled foreign companies, they're going to be taxed at a progressive rate of 0 to 22.5% rate. Profits generated from January next year will be taxed at the end of each year. Profits generated until the end of this year will be taxed at the moment of availability only. Losses generated starting next year can be compensated. If the individual will have the opportunity to deduct the income tax paid abroad by the controlled foreign company. So that would be, Stefania, the main topics that I would like to cover. Let me stop the screen sharing. I'm
Thanks,
sorry
Marcelo.
for taking too long. My wife says I speak too much, so maybe she's right.
No, thanks, Marcelo. I think that, you know, that the presentation and the whole explanation was necessary, taking into consideration the recent change in the legal framework in Brazil. I'm not a Brazilian expert, so from what we have discussed, I understand that this bill at least gives more certainty of where the Brazilian legal framework stands regarding foreign trust. So yeah, I definitely necessary to go deep into the explanation, taking into consideration that this change is so recent. I don't know if any of the members of the audience have any questions regarding any of the matters that were discussed during this webinar. Well, if any of you want to do that question in Portuguese, that's totally that's good as well. Marcelo will answer, and we are looking to publish a memo after this presentation in English and Portuguese. So, well, I don't know if.
Yeah, what I would say is that I think the majority of the people listening to the webinar is Brazilian or Portuguese speakers. They can feel free to ask if they want so. If not, they have our contacts. I believe, Stefania, I would say they can feel free to reach us out via email. And I would just ratify that we're going to share with you all a memo, bi-column memo in both in Portuguese and in English. And we remain at your disposal to clarify those situations. And I would suggest from now, Stefania, that we can hold another webinar within, I don't know, 3 months, maybe, just to make a follow-up of the discussions in regard to the MP 1171, because I believe that there's going to be plenty of material and situations for us all to discuss and to give guidance to our clients, whichever they are in, whatever are the needs.
Definitely we can do a follow-up webinar in a couple of months after, also to give the updates after this bill has been processed. Okay, thanks to everyone who attended.
Thank you all, and
Thanks,
have a nice
day. Bye.
You too. Bye-bye.